So welcome everybody to our contentious clinic for October. Thanks everybody for joining today. It's really nice to see everybody here and the continued support for the clinic. I just thought I'd start off this month by just giving a bit of context as to why we host the clinics. So we've been hosting the clinics now since February time. So I think this is around our seventh one. IDR Law. At IDR Law, we are the only firm in the UK that deals with contentious probate solely. We don't do any other area of law. We basically created the IDR network, which is our referral and support space. So the reason why we created that is because we have a whole host of referrers who refer work to us monthly. And we wanted them to be able to access all of our resources and content and training in the area of contentious probate. And that's how the Contentious Clinic was born, basically. We wanted to provide them training on a monthly basis on all different topics provided across the IDRN. This month, we are running a session on will validity challenges, and we are joined by Georgina Coates, a solicitor from IDR Law, and she is being supported by Richard Thomas, one of our partners. So without further ado, I will hand over to Georgina for this clinic. And thank you very much for joining us. I think this is your first one, isn't it, Georgie?
It is. So yeah, go easy on me, everyone. Thanks. So I just like to echo what Lindsay said. So thank you so much for attending today. And without further ado, so today's presentation is going to be on probate claims, with a specific focus on the claims that can be brought to challenge the validity of an individual's will. Just say as well, there will be an opportunity at the end if you'd like to ask any questions. So please don't be shy if you would like to ask any. So just to start with can everyone see that actually? There we go. Just a brief summary of what I'm going to discuss today. So we've got probate claims. What are they? The main features of probate claims, the specific types of probate claims, and the challenges that can be brought. We're going to talk about with a focus on the most common types of probate claims in that sense. And then a focus on testamentary capacity and undue influence claims. And Richard's going to be discussing more of a focus on the practicalities involved in sort of researching and evidencing those sorts of claims. So just to talk about what probate claims are in general. So the Civil Procedure Rules defines a probate claim as the grant of probate of a will or letters of administration of the estate, the revocation of such a grant, or a decree pronouncing for or against the validity of an alleged will. So in terms of these, in the above context, probate claims therefore relate to claims to prove a grant of probate or a will of the deceased, claims to seek to revoke a grant obtained, or to claim for a decree pronouncing against the validity of a will. Today we're going to be focusing on the latter, i.e. claims seeking to ask the court to pronounce against the validity of a will. I would firstly caveat that it's more likely that a challenge to the validity of a will would be settled between the parties prior to any sort of determination of asking a court to make a determination on that. But obviously you'd have to put forward any claims first as part of a letter of claim. So the main features of probate claims are typically eligibility. You've got to make sure that someone is eligible to actually make a challenge to that will. So generally in line with that, you need to either make sure that somebody benefits under a previous will to usually a greater extent, or either benefits under the rules of intestacy, or even a further will further back, depending on how many wills have been made. Dissatisfaction. So normally the cause for a validity challenge or a client wanting to make one is on account that they are unhappy with the provisions of a will. It could be that they're not happy that they maybe don't receive as much as they did under a previous will or intestacy, or it could be that somebody else receives more than they would want them to, as can be on occasion. Probate claims are extremely heavily investigations based. So the first port of call, if a client suggests that they would like to potentially make a challenge, would be to make investigations, and then usually provide some further advice as to the merits or proposed merit based on those investigations. And because of that, they are often very expensive and time consuming. So you always want to make sure that initial investigations are done, and then that clients have an opportunity often to reflect on what they'd like to do in terms of the next steps.
More bread. Oh.
So in terms of the most common types of...
We've got this potential contentious one coming up.
Okay. See you in a minute.
So sorry, I'll just continue. So in terms of the most common types of probate claims that can be brought, this would be claims for lack of due execution of a will, claims that the deceased lacked testamentary capacity, claims that the deceased did not know or approve the contents of a will, claims that the deceased only made a will because they were unduly influenced to do so, or that the deceased mind was poisoned against another individual or group of people, choosing them to decide to ultimately leave their estate in a different way than the otherwise would have done. These are the most common challenges to wills that we see, but I would just say as well that there are other challenges or claims that can be brought, such as fraud or forgery, but I'm not going to focus on those today, as those are generally quite rare and it's sort of difficult to prove in any event. So I'll just go through and explain a little bit more about these in a bit more detail. So first claim that we do see, I'd say this is one of the less common ones, but surprisingly we are seeing a few more of these types of cases coming through. So this is lack of due execution of a will. So it's seeking to challenge the validity of a will on the basis that it wasn't duly executed in line with the provisions of Section 9 of the Wills Act. I'm sure many of you will be aware of these provisions, so I'm not going to sort of go through them or read them, but they're on the screen for your reference. Although the above appears relatively simple to follow, in essence that the will must be in writing, signed by the testator, that the signature is acknowledged or made by the testator in the presence of two or more witnesses, either present at the same time, or the testator's signature is acknowledged in the presence of each witness, but not necessarily in the presence of the other witness. It is easy for mistakes to be made. If it can be demonstrated, for example, by one of the other witnesses or by video evidence that the provisions of Section 9 were not adequately carried out, then there's no defence to this claim, and the will be invalid. So it's therefore important that will writers and solicitors do take adequate steps to ensure there is as little chance as possible that the will could be found as invalid on these grounds. Some of the suggestions that we would sort of typically put forward for ensuring that a will does comply with the Section 9 formalities, you know, that you don't end up in a situation where, you know, a will is, you know, has not been validly executed, would be to ensure as far as possible that a client actually attends your offices, or that you carry out an at-home visit to ideally ensure that the testator signs the will in the presence of two witnesses at the same time. That you send out clear instructions to the testator if the will does need to be posted or sent to them electronically, so they have a guide as exactly what they need to do to ensure the will is validly executed. So the best thing to do is to explain this in very clear terms, sometimes potentially in the form of a flow diagram can be helpful, so that, you know, there's no potential misinterpretation of legislation. It's always good to make further calls to ascertain confirmation that the testator understands how to validly execute the will, and to also make further calls or write out to the client testator to ensure that they've taken steps to arrange the execution of their will. So the next area and a challenge that we do see, probably this is one of the most common ones, is trying to challenge a will by way of lack of testamentary capacity. So in order to make a valid will, you know, as you'll know, the testator must have to have testamentary capacity. The test which remains good law for the test of testamentary capacity is in Banks versus Goodfellow, and is the common law test. requiring a testator to understand the following. So nature and act of making a will, the effect, nature and extent of the property which he or she is disposing of, any potential claims on his or her estate, and also that they must be suffering from no disorder of the mind. So a lot of you will be familiar with that test, but just briefly and taking those in turn to address them. In terms of the nature and act of making a will, those taking instructions should always ensure that the person giving instructions has an understanding of the process of making a will, what a will actually is and what it does essentially. So that, for example, would be ensuring that, you know, a will, they know that or are aware that a will only comes into effect upon death, and that during their life they can revoke any wishes or add to these, you know, by way of, for example, making a new will or by codicil, if they do wish to do so. This is not a list that's intended to be exhaustive, but just an example of some of the things that you know should be checked really. As to the effect of making a will, it's just taking care to ascertain that the testator understands the effect of making a will might not always be linear and as intended. So, for example, some beneficiaries can predecease a testator. And so they should be encouraged to consider other options or default clauses as part of that, and that they understand that and are aware of it. Regarding the nature and extent of property, this is referring to the testator being able to understand, have knowledge and recollection of the property he or she owns. So this could be in relation to checking that they understand how their property is held, whether it's solely or, you know, jointly, tenants in common with another person, the value or approximate value of that property, what they have in bank accounts, and, for example, any share portfolios or, you know, anything like that. It is generally, I would say, an approximate value of someone's assets that should be ascertained. It's not, you know, a test of perfection and recalling absolutely everything, but, you know, a generally good, competent understanding of what they have, you know, should be ascertained. Regarding the claims on her estate, it just generally involves the testator understanding and appreciating any moral responsibilities or obligations which may have towards others, as well as the competing needs of others. So it's important for those taking instructions to confirm that a testator has the capacity to give his or her reasons for the exclusion of, you know, or more minor exclusion of beneficiary or beneficiaries in comparison to others. There is absolutely no legal obligation for a testator to leave their property in a certain way, you know, or in certain divisions. However, they should be capable of verbalizing, you know, and reasoning the for why they've decided to do it in that way. This is also relevant, of course, to potential claims against the estate under the inheritance provision Family Independence Act. So it can be a good thing to make sure that clients understand the potential implications of that and can reason with leaving amounts in their will if it seems or appears relevant to do so for certain beneficiaries. And with regards to not be suffering from any disorder of the mind, obviously in some cases this might be inherently obvious, or a testator might inform you that they do suffer from a disorder such as dementia. This does not mean that they are incapable of making a will or don't have testamentary capacity to do so. But where you do have a testator who is elderly, infirm, already has a illness such as dementia, or has suffered a serious illness recently, then the golden rule as set out in Kennard versus Adams should be followed. So just to briefly go over that as well, the golden rule confirms that the making of a will should be witnessed or approved by a medical practitioner who satisfies him or herself with the capacity and understanding of a testator and records their examinations and findings. So this could be, for example, ensuring a capacity assessment is carried out prior to a testator making a will in these circumstances, or having a medical practitioner witness the will. I would say in cases such as this, it is a good option have a capacity test carried out, and then to have that same doctor witness the will on the day that it is executed, just to ensure that you have almost a double opinion on each of those days, as capacity can obviously inherently fluctuate. The golden rule is it doesn't have to be followed. It's not an absolute stipulation in these sorts of cases, but I would say it's good practice, you know, to want to do that, and it's helpful to have done so. A further claim that we see quite a lot is that of lack of knowledge and approval of a will. So this is where a person propounding a will must show that at the time the will was executed, the testator knew, understood and approved the contents of their will. It'd be prudent to first mention that where a will is duly executed, and there's an attestation clause, and the will on its face appears to be rational and fair, then this raises a presumption that the testator did have knowledge and approval. There's also a strong presumption that a testator knew and approved the contents of the will, where that will has been executed by someone with testamentary capacity, and is being professionally prepared by a solicitor, and duly executed, read over to the testator prior to signing. Just got some of the difficulties that usually cause rise to a claim of knowledge and approval, just on the slides there. So this is normally in cases where you have a mistake that's arisen in terms of the preparation of the will, leading to a presumption or belief that the testator was unaware of the mistake and therefore didn't actually approve the contents of the will. You've got a testator who suffers from some form of disability, such as blindness, deafness, or illiteracy, which can of course cause difficulties in terms of actually providing instructions. And there is doubt about the testator's testamentary capacity, as aforementioned, so I won't go through that again, but often you see these two together, and or, you know, the circumstances surrounding the preparation of the will are suspicious and require further investigation. As I said, it's common for us to see a claim on this ground usually put forward and accompanied by a claim that the deceased did not have testamentary capacity, or with allegations of undue influence, which I'll talk about shortly. It's therefore important for a solicitor or will writer to ensure that detailed attendance notes are taken throughout any matters, that instructions are provided to them by the testator only, if possible. Also, that the solicitor ensures that the testator is alone when providing their instructions. It's also of pivotal importance that instructions are not accepted by anyone other than the testator, except in really exceptional circumstances, and you've made adequate checks, you know, to ensure that those are actually the instructions of the testator. For example, if you've, you know, had a phone call and then something's confirmed to you by email by someone who's assisting the testator, but those instructions accord with what you've spoken to on the phone, for example. And if it's necessary for a home visit to be made in order to confirm your instructions, then it's always best practice, if possible, that this is done, just so that you can satisfy yourself that there are no issues in this regard. So one of the other claims that we see, and this is normally one that isn't typically advanced unilaterally, it normally is accompanied by a claim for testamentary capacity, or the above. So in terms of undue influence, the burden of proving this is on the party who alleges it. So this ground is really quite complex and turns on the circumstances and factual situation at the time of making the will, or in the build-up up to that. In essence, undue influence means influence exercised either by coercion or by fraud, and as of such, of nature that the tester's will is overborne by it. The case of Ari Edwards provides some useful checkpoints on this, and what sort of undue influence is and can consist of. I won't go through them, but they are on the slides, and we can provide that after the seminar. I would say again, obviously, undue influence is extremely difficult to establish, although some recent authorities do appear to suggest a slightly lower evidential burden than previously. But the main issue with undue influence is that it's very situation specific, and it often happens behind closed doors, and is such away from other witnesses to it. Undue influence must also be as a result of coercion, and not just bad influence. For example, persuasion or advice can be given without this amounting to undue influence, but this can of course constitute as loaded advice, and be provided over a certain amount of time, and in a repetitive way. So the final challenge I'm going to talk about is that of fraudulent calumny. So this is a claim that we don't see as often. However, we are starting to get this through a little bit more, which is quite interesting. I'm not going to go into this one in too much detail, but I would say this to say that this, simply put, fraudulent calumny may occur where a beneficiary of a will makes untrue comments to a testator about the character or motivations of another potential beneficiary, in order to reduce or remove their entitlement under a will. So in some ways it has a similarity with undue influence or can do, in terms of negative statements being said. And there is obviously an influence aspect to it, but fraudulent calumny does differ. So, for example, in undue influence cases as above, the testator is required to change their will against their free will. So, whereas in fraudulent calumny cases, the testator's mind is poisoned against the potential beneficiary, such as that they change their will by their own free choice. So that's the key distinction between those two. So I will now just pass on to my colleague Richard, who's going to talk to you a bit more about the practicalities of making claims and evidencing claims relating to specifically testamentary capacity and undue influence.
Thank you very much, Georgie. I hope everyone can hear me. And apologies for my far more dull and boring slides, not as beautiful as what Georgie and Lindsay have created. What I thought I'd do is look at testamentary capacity briefly and then undue influence even more briefly, given that we're 24 minutes past, just to give you a bit of a sense of some of the more practical elements and to highlight some things that I think, or we think IDL are sort of important and relevant. I think much of what I'm going to say in respect of testamentary capacity is also relevant to other claims as well. So I think one of the key things is the court's going to take an inquisitorial approach to probate claims, and that does not mean that the Costage and Chaplin costs exceptions are always followed, and that's where sometimes, if in a failed probate application, the court does have the authority to order that costs are borne from the estate. That can happen. I'm not going to go into the way, but that's not the default. But it is open for the court to do that because, as I say, it's an inquisitorial sort of approach that the court will take to looking at all the evidence, which is why it's so important that the evidence is gathered in the right way and also that it actually supports what you're going to say. I think what Georgie said at the beginning is paramount. Quite often what we see is people who come with a view of, I don't like this will and therefore it must be incorrect. And then try and almost retrofit some of the probate claims to that. And what you can see, therefore, is that you get, 1, 2, 3, 4. I've even seen all 5 of the claims that Georgie said in letters of claim, and that's never a particularly strong position to start from, because I would always say you need to be specific, and I'll go on to that. But they're very different claims. You only need to succeed in one of them, and the more sort of muck you throw at a wall, I always think the less likely it is that all of them are particularly good. So inquisitorial approach is important, evidence is important. Again, picking up on what Georgie said, especially with testamentary capacity and undue influence and so forth, it's really important that there's an absolutely clear understanding of why you're bringing a probate claim. The nice thing about probate claims is that they are binary. The court has very little discretion on what it can order. Either this document before you is valid or it's not. If it's not valid, it goes back to the previous valid will, or if there's no previous valid will, it's the rules of intestacy. And that seems simple, It is simple, but it's amazing how often we get claims where that no one's really thought about what happens if they do succeed. Because it's not enough to succeed in persuading the court that the will is invalid. You need to also ask the court to persuade in favour of a previously valid will, or the rules of intestacy. So one of the things we would always say is make sure you've got a really rock solid foundation in terms of, if I am successful in knocking out this will for whatever it is I want to run, what am I doing, or what am I then asking the court to pronounce in favour of, and am I certain that that is the case? Could there be a will that we don't know about? Have we really made enough investigations in terms of previous wills and that kind of thing? Are we certain that we inherit to a greater extent, or at least the same extent? And is there anything else that could happen in the meantime that could cause a problem? As I say, it wouldn't be the first time I've seen challenges, even pretty good ones, be completely destroyed on the basis that a will turns up, which doesn't help the claimant at all. So that's one thing. And also, whilst this is all only going to be indicative, I also think that, eventually you're going to be trying to tell a story with the evidence. So I think one of the key things I always think at the beginning is to look at the suspicious factors in terms of, some things jump out immediately. Wills that are close to the date of death are something that are immediately or potentially immediately suspicious. If you're trying to challenge a will that was made in 1988 and the testator, the deceased, died last week, already you're going to have some difficulties in terms of length of time, and people's ability to recall events, your ability to be able to get will files and all that kind of stuff. So that's important, I think, to set the tone. Do we have too many wills too close together? We did a case recently where two wills were 2 weeks apart, which caused a problem as to how you could distinguish the evidence between this will on day 9 and this will on day 0, making it very, very difficult. And I think also, looking at all, what's the change? One of the most powerful things you can do before you even go into any of these particular claims is to kind of show the testator's testamentary history. And if you've got 5 wills giving everything to Poppy and Jack, and then suddenly this will turns up and it gives everything to Lindsay and Georgie, that's something that obviously you would say demands an answer, because you might say it's a claim that's not particularly rational. And again, I've seen, that's a powerful starting point. So if you've got wills close to death, extreme changes in where they're going, and you're pretty certain of what you're aiming for, i.e. that if I knock this will out, I as a claimant am going to benefit, that's a key starting point. I think looking more in particular at testamentary capacity, you remember that Banks and Goodfellow is a legal test. This isn't anything, and medical evidence is important, it's only one part. And what I mean by that is that quite often you'll have people who go, so-and-so was confused and I can prove memory loss and therefore they would have lacked testamentary capacity, or so-and-so was diagnosed with cancer and therefore they would have lacked testamentary capacity. That doesn't work. It's a legal test and medical evidence is only one element of it. And whilst Alzheimer's or dementia or alcoholism or even extreme grief can sometimes be indicative of testamentary capacity, that's not the whole case, and nor does any one of those particular things mean that necessarily you're going to be able to knock out a will for not complying with Banks and Goodfellow. And I think that's something that's really key to understand when you're sort of defending or bringing a claim. And as Georgie also said, you've got to be aware that capacity can be fluctuating. And therefore, a diagnosis of dementia in 2020 does not mean that a will in 2021 necessarily was made without testamentary capacity. I think 3 key bits of evidence I would say are, which are essential to have a look at. I would always start with the will file. That is the most important thing, I think, to start with. Was it written by a professional? What does the will writer or solicitor or the person who wrote the will say? Is there attendance notes, emails, telephone? All these kind of things are absolutely essential. Most of you, I think, if you practice in an uncontentious or even contentious, will have dealt with Lark and Nugis requests. These are the requests which potentially allow a claimant to waive privilege under certain circumstances. and the will file is so important because one of the key cases recently, which is Hughes and Pritchard, I think it's a Court of Appeal case. It's now in the Supreme Court. I think it's just been. It's a lot of that was actually to do with proprietary estoppel, but the relevant parts of it were looking at these different caches of evidence. And effectively, what the Court of Appeal said is that the evidence of an experienced will writer is going to be very strong. It's going to be very difficult to overcome. And I'm paraphrasing here, and it was written far more eloquently, but it's an important case because when you're balancing evidence of a will writer and will file, potential witness evidence and contemporaneous evidence, and then you've got medical evidence as possibly the third cache, there's always been debates in different cases that sometimes tilt it in one particular way. This is the most recent one, which says, as I've always sort of thought really, that judges tend to be more persuaded potentially by people who were there at the time. And therefore, if you've got a will writer who is extremely experienced, who has extremely good attendance notes, who followed the golden rule, etc., that is arguably going to be more persuasive or very persuasive, even if you have medical evidence that might suggest otherwise, or you've got some witness evidence that might suggest otherwise. None of it will definitely beat anything in particular, but you need. I think the recent case law is pretty strong in the fact that if you're going to be struggling, I think, or at least you're going to have a high hurdle if you have experienced will writer that was there. I think that when you're looking at that kind of evidence, medical evidence obviously is important. One of the things to remember with medical evidence is it can take a long time to get things. So, decisions need to be made fairly early on, fairly quickly about whether that's something you want to look at. And the second thing with medical evidence is that quite often you see, people like Georgia or I going through and highlighting bits and saying, oh, well, all this combined means that, they clearly didn't have capacity. We're not lawyers, we're not doctors, in the same way that medical experts and doctors aren't lawyers. And so it's very important, I think, if you're going to build a case based partly on medical evidence, that you consider having a retrospective capacity report, because this is someone who can opine and actually talk about the medical factors. And again, a good medical report will talk about the medical side in connection with Banks and Goodfellow, but they won't go straight into the legal side, where they won't second guess what witness statements or what particular testator will say about who's more persuasive effectively. They might say, if the court were to side with this witness evidence, or if the court decided that this was persuasive, you might find this. And therefore, again, if you're doing medical evidence, it's a very important part of a testamentary capacity case, because it can be highly indicative of a lack of testamentary capacity. And I would always say, if you really want to land a blow on medical evidence, you ought to consider a medical expert. And a good medical expert will give you a kind of abortive element at the beginning, where you can go and check your evidence before having to reveal anything to the other side. I think the third type of evidence, as I alluded to before, was sort of witness evidence and contemporaneous evidence. And that can be anything. That could be evidence of someone paying invoices. I've had evidence before where showing that someone rode their scooter every day to a particular point, bought their paper every day and had the capacity to live independently and did all these things, and all that was relevant. Witness evidence on the day or around the relevant time is also incredibly important, because again, these are people who saw the deceased at the time, and therefore a claimant would argue, or a defendant would argue in the reverse, that they hadn't, this wasn't in contemplation of the claim, they saw this person at the time, and therefore retrospective evidence may not be as powerful as people who were there at the time. What I would say, however, is remember that all these people who may or may not support or not support a case, whether that's the will writer, whether that's the medical expert, whether that's all the witnesses and the friends and the family, all of that ultimately needs to be tested. So at some point, the key actors in any claim ought to be tested by us, by counsel, in good time before trial, because the litigation risk in this is significant, because it's so binary. And therefore, you need to get as good an idea as you can about how persuasive people are. And if you look at the case of Hughes and Pritchard, I think we'll be sending around a factory time. One of the issues here was a medical expert sort of second guessing and doubting themselves, and people tripping up and so forth. So even with good evidence, it's not infallible, because you're dealing with people, and you're going to be dealing with people ultimately who may be cross-examined. even if, as Georgie says, lots of these cases do get settled. So for one very, very quick example, without being particularly specific, we had a letter of claim that came in. There's a clear, everyone agrees there was a cancer diagnosis, brain cancer. The will was made short before death. This chap was suffering from confusion, memory loss, headaches, was going through quite intensive chemotherapy and radiotherapy at the time. All things that would possibly lead someone to bring a claim. And it was also supported by a report. So there was a medical expert who reviewed the evidence and said he believed on one of the limbs that this chap didn't have testamentary capacity. Looks pretty damning. However, we were able to get a report on the other side, which actually ended up leading to the claimant's expert sort of downgrading their report. There were two very experienced partners from different firms who saw this gentleman at the time, both of whom were adamant that this person had testamentary capacity, both of whom asked the right questions in line with Bex and Goodfellow. You had a whole plethora of witness evidence from people, whether it was people at a bank, whether it was other solicitors, whether it was friends and family, and crucially, evidence from 2 or 3 people who, by chance, happened to see the deceased on the day he executed the will, and they did various things with him, and that was incredibly important, and also other evidence about carry on the business and that kind of thing. And that was enough to cast sufficient doubt on the claim for it to be settled in a very sort of beneficial way to the defendants. And I think that's a good explanation of where, even if you've got a medical report and it seems conclusive, it's not necessarily going to be enough, or I would say probably isn't going to be enough if you've got really good evidence from the will writer and very good attendance notes. And also evidence from people at the time who were there on the day. And very quickly, because I know we're running over, undue influence, as Georgie said, is very, very, very difficult. It tends to be the kind of claim that almost everybody comes in and says, I think so-and-so is undue influence. It's so difficult that when I attended a talk from Professor Robin Jacobi, who is a retired now, he was a sort of doyen of capacity experts. And whilst he did reports for capacity, he was often asked to look at and whether someone could be susceptible to influence. And one of the things he said in his talk was that he'd actually made various comments to the Law Society and so forth to try and weaken the law, if you will, about undue influence, because it is so difficult. You're trying to prove effectively active coercion in its simplest form, and this is not the law, this is sort of me paraphrasing again. You're trying to prove that someone did something knowingly that they didn't want to do because they were scared or afraid of somehow of some kind of consequence. That's incredibly difficult, especially if you've got a solicitor who sees them or a will writer who sees that person and is asked the right questions and people aren't in the room and so on. It's very, very difficult. And even though the law recognises that this kind of thing often goes on when no one's looking, it doesn't make it any easier. There is a particular paper from Pisa et al., I think 2008, which looks at undue influence and red flags. There's been a sort of recent one. It can be quite useful. It breaks it down into sort of 3 main areas: sort of social, environmental, psychological and physical, and legal risk factors. So things like frailty, vulnerability, and whether there were changes and people being ostracized and all that kind of stuff. Even with all that, they're just red flags. They can be indicative of, but showing actual undue influence is very difficult. What you sometimes find is that either defence but claimants try and shoehorn undue influence into lack of knowledge and approval. It can be there's a way of doing it that makes it slightly easier, possibly to plead, and it can kind of be a wolf in sheep's clothing, as it were. But as Georgie said, singular cases of undue influence are quite rare and very difficult. And also, especially rare are the circumstantial cases where all the circumstantial evidence leads to it. There's a particular case called Schrader, which is always quoted in almost every letter of claim about a case which was successful based on more circumstantial evidence. But there has been a recent case of sort of Rhea and Rhea, or Raya and Raya, which is a fairly rare one to come through. And again, that did lead to it, and it had a lot of the sort of red flags that you might talk about. But it's very, very difficult, and so difficult finally that on a very brief example, we had one where a lovely chap with a very wholesome sort of family, 2 daughters, passed away. A year before, I think almost a year, 18 months before, he had met someone and fallen for her very, very quickly after the will was changed. And it was a complete change. It had always been to his daughters, and suddenly it was now to this new lady. They weren't married, but he was, on any view, people had to accept that he was, particularly into her, for a better word. And we managed to get an inordinate amount of witness statements from everybody, from the garden club to restaurants to family members to, people we would form as objective witnesses as to the change in this person, how he never attended things anymore, how he seems to be ostracized. However, when we answered, we called the house, and this lady would answer, and it would be him, and all these, tens of witness statements. But those alone are not enough. And the case was settled, but it was very difficult, and it wasn't the kind of result that you might think reading all these witness statements, because actually, he was seen by a solicitor who he was seen on his own. And there were various elements in that case that made it incredibly difficult to prove that this person was, at the time the will was instructed upon and executed, that he was actually being made to do something that he didn't want to do, and which wasn't, it may have been a silly decision, or it may have been foolish, but there's no law against that. So under influence is incredibly difficult. It's not impossible, but it is hard, and it's one thing we always advise clients that it's, out of all of them, it's possibly the hardest. Anyway, apologies for going over. I will pass back to Lindsay to post any questions. Yeah, lovely to speak to you.
Yeah, thank you so much, Richard, and thank you, Georgie, for that. That was really interesting. I'm just going to check if we've got any questions. Please do add to the chat if you have any questions at all. And we can just keep an eye on that while I just run through the stuff on the IDRN. I'm just going to put a link in the chat for the IDRN and how to register to that. So I think probably quite a lot of you on the call are possibly registered, but if there is any of you that aren't, please do register today and share with your colleagues. Somebody's asked in the chat if the presentation and the slides are going to be available, and that is going to be all accessible via the IDRN after the session this afternoon. As mentioned at the beginning of the call, the IDRN provides access to everything that you need should a contentious case land on your desk. There's a triage area which highlights our 4 most common contentious issues and quick guides and what to do in those events. You can also fast track a client via our referral space, and there's lots of legal tech tools in there to help you in preventing claims, essentially. So that leads me on quite nicely to our charity claim checker, which we are in a soft launch of this week. Would you mind just skipping to the next slide, Georgie, please? Thank you. Yeah, I think it's worth highlighting this because there's quite a few charities on the call today. Following the successful launch of our IDR claim checker for the wills and probate sector, we have actually been working closely with the ILM, the Institute of Legacy Management, and Legacy Link and other legacy officers to create a tailored version for charities. So basically it is absolutely bespoke to legacy officers. It's an online tool that will help junior legacy officers and legal teams working in charities assess the merit of a claim against that charity, against your charity, against your legacy. So when that dreaded claim letter lands on your desk and you don't know what to do, you can simply enter the details of the claim and that will assess that claim for you. So give guidance on all types of claim, but also provide a report on 1975 Act claims as to whether the claim has merit or not. And it will also fast track for court proceedings as well. That is going to be available via the IDRN this week. So we are pushing for that to be ready tomorrow, but definitely by the end of the week. So it'll be via the IDRN, and the Institute of Legacy Management will also be hosting that on their website. So for anybody who isn't subscribed to the IDRN, please do subscribe and you'll be updated as to when that comes out. Last to mention is our contentious clinic for November. That will be hosted by one of our trainee solicitors, Hannah Coaten-Smith. She will be supported by one of our other partners, Cara Hoff, and they will be presenting on the case of Bowser versus Smith. So please do register again to the IDRN to be updated of details around that, so you can get registered for that next session. But I think if there's no questions left, any questions in the chat, please, if anyone's got any questions, please just contact Georgina or Richard directly. I'm sure they will be happy to help. And I think that just wraps up everything for today. And thank you again for coming. It's been a good session. Happy Halloween.
I've just seen actually Emmanuel. I think you've asked a question. What I'll do,
Yeah, there is a question. Yeah.
It might be. Is it easier for me to email direct? I don't mind speaking.
Well, yeah, maybe just cover it off now if you want to, or
yeah, I think Emmanuel asks that some clients decide to keep their will to themselves, and how can a will draft ensure if possible that clients conform to instructions included in the will if the beneficiary challenges it in future? What safeguards could a will draft put in place in the above scenario? I think that the best thing, you can never stop a claim, and you can never stop, even if you have the best protected file in the world. I do think that, ironically, keeping something to yourself can work against you sometimes, because people will say, well, they had an amazing relationship with mum or dad, they would never do that. We always talk about everything, and therefore, it was hidden for a reason. So I do think that in many ways, if you've made a decision and you've instructed upon and executed a will, but actually sharing that, sitting down with people earlier rather than later, so that you can evidence that they were well aware of this at the time, can help. The best thing you can do, I think, is to make sure that you've got fantastic, attendance notes, you ask the right questions, and that you keep all of that on file. Letters of wishes are very important as well. They're not binding, but at least that gives you a bit of a flavour. And as I say, really good reasons, and exploring and asking about the previous will, explaining why you've done it, making sure that they have a sense of what's in the estate, making sure they understand all those things, and following the golden but tactless rule if you need to. And I say that's the best you can do, even if you have, you try and put things in where, clauses that limit people or dismiss people's inheritance should they challenge wills, all these kind of things will mean nothing if the will isn't valid. So, as I say, the best thing you can do is just prepare your defence in advance. I would say, and hopefully, that will help. And you won't. But unfortunately, if someone's going to try and challenge the will, you can try and make it very difficult. One sort of practical thing I would say quickly is that if you update wills fairly regularly, even if they're consistent, you then start to get touch points in a testator's life, whereby, let's say you're changing the will, you've got a 2008 will here, and then you change it once. That the claimant therefore has one chance to knock out a will, and it goes back to something maybe that benefits them. If you've updated your will on a biennial or every 3 years or so on, even if it's the same thing, you're just updating addresses, it means practically that a claimant has to knock out 1 or 2 or 3 wills that maybe they say the same things, mean that to get to the will that benefits them, you're suddenly looking at knocking out 2 or 3 wills with good amounts of time in between them, as opposed to knocking out 1 will right at the end. Whereas if you do that, it goes right back to 2008 or even before. So that was a tool, even if there's nothing to change in terms of who the beneficiaries are. Updating your will and with addresses and so on, even if it's the same thing, I think creates those breaks in time whereby, as a claimant not only has to prove under influence or so on at this point, they then have to do it in 2020, they then have to do it in 2012, and it becomes incredibly unattractive to do it. So I think practically that's probably the best tip there is to avoid it.
Fab. Thank you, Richard. Brilliant. Well, if that's everything for today, then I think we can wrap up, and hopefully we'll see you in November for our next session. Thanks, everybody.